different parts of the state at the end of this meeting. We ask for your protection for those that are here. We thank those that are here to protect us. In Jesus' name we pray. Amen.
Amen.
All right, roll call.
Yes, sir. Have Chairman Rick Fedor,
Here.
Vice Chairman Tom Butler,
I'm here.
Dr. Ray Callis, Dr. Gary Wesson,
Yeah.
Commissioner Helen Collier, and Commissioner Nora Castaneda.
Here.
And it looks like we have a quorum.
We have a quorum. It's great. For those of that are here in person, the audience must remain quiet because the microphones are in the ceiling. They're very sensitive and pick up a whisper. And any commissioners, there's no commissioners online. So we're going to go to item C, if you will, which is recognition of Bill Kuntz. Mike, you have the floor.
Yes, Chairman Commissioners, Mike Harris-Menace with the Executive Director for the Texas Porn and Licensing Regulation. Recently, about a month and a half ago, we lost a dear friend to the agency. Bill Kuntz served as the Executive Director for 17 years. The foundation of who we are as an agency, the culture that he established in the agency, is a living legacy for who he was as a man and what he did for this agency. There was a couple of us that managed to serve with him that as he was executive director. I was fortunate to be able to be on the commission for about 14 years and working with him directly. I believe our vice chair, Tom Butler, also was there, and I believe Chairman Figueroa was with him for a few months before he retired. So Bill Kuntz passed away, and he left a huge void in this earth with his passing. But he had everything situated, ready to go, which was typical Bill Kuntz style. When he left the agency, they were in a great position. When he left this earth, his family's in a great position. So we just want to recognize the passing of the former executive director, Bill Kuntz. In our August meeting, we'll have a formal presentation where we have his family here. I've already notified the family, so they make plans to be here in our August meeting. We'd like to do a formal presentation then of recognizing Bill Kuntz, but we didn't want our next meeting to go by without actually formally recognizing the passing of this great man that what you see the agency now is Bill Kuntz. He's got his fingerprints all over it. And so we did want to recognize him for that.
Thank you, Mike. We do stand on his shoulders, so we're going to have a moment of silence. Thank you, guys. Appreciate that, Mike.
Thank you so much. Did we, going back to the roll call, have excuse the absences of the two? Unless you don't want that. It's going to be up to you.
Yeah, we'll get it. We'll get that. I take the motion to excuse the absence.
So moved.
Second.
I'll second.
All in favor, say aye.
Aye.
Opposed? Okay. Motion carries. We're going to item D, which is public comment. We're accepting public comments in writing in person and by video conference call for those who are submitted requests in advance to speak to the commissioners. Commissioners, you've received some written comments, and so we'll go up to the first commentary. Right, so
Thank you very much. We're gonna have Ms. Nicole Kosich up first, and she is present.
Oh, you're live. Nice. Good to see you.
Good to see you too.
Okay.
Technology can be a challenge, so
So let me, I'm gonna read
it's
some,
better to come in person.
I'm gonna read some instruction to you real quick, okay? Then you'll have 3 minutes and Carnation will keep time, okay? Thank you for being here. Please say your name and who you represent. You'll have 3 minutes to speak. Please understand the commissioner is not allowed to ask questions or engage in discussion with you about anything that is not specifically on the agenda. Please also understand that commissioners cannot hear any information about a pending complaint or enforcement case because the way we may ultimately be the decision maker in the case. Do you understand?
Yes, sir.
Perfect. You have 3 minutes. You have 4.
Okay. This won't take 3 minutes. My name is Nicole Kosich. I'm Nicole Annie Kosich. You have me under my former married name as well. I'm here to request reasonable accommodations under the law. And if you have any questions, I'll be happy to answer, or if a meeting can be scheduled to do so, that would be great. That is all.
That's it. All right. Well, thank you. I appreciate it.
Thank you.
Cautious, right?
Yes, sir.
Thank you. All right.
All right, and up next, we can move William Henninger into the meeting room, please.
Henninger.
Yes, Henninger. Mr. William Henninger.
Mr. Henninger, can you hear me? I don't see him.
It looks like there's a bit of a delay. Our apologies.
There you go. Mr. Henninger, can you hear me?
I can, yes, good morning.
Okay, this is Chairman Figueroa. I'm gonna read you some instructions. You have 3 minutes, okay? Just let me go through these instructions first, if you don't mind.
Thank you, sir.
Thank you for being here. Please say your name and who you represent. You'll have 3 minutes to speak. Please understand the commissioners cannot allow to ask questions or engage in discussion about anything that is not specifically on the agenda. Please also understand the commissioners cannot hear any information about any complaint or enforcement case because it may ultimately be the decision maker. Do you understand, Mr. Herringer?
Yes, sir.
Okay, 3 minutes. Go ahead and go.
Thank you for the opportunity to speak. My name is Bill Henninger. I'm the sanctioning director for WACO Team USA Kickboxing. WACO, W-A-K-O, stands for World Association of Kickboxing Organizations. WACO is the largest kickboxing organization in the world, currently operating in 122 countries with over 1 million members. WACO Team USA Kickboxing is the American license holder for WACO, and we have held this license since 2013. In 2018, WACO Team USA Kickboxing was recognized by the World Games Association as the national governing body for amateur kickboxing, and we assisted with the selection of Birmingham, Alabama as the site of the upcoming World Games in July. Recently, kickboxing has been officially added as an Olympic sport by the International Olympic Committee, and WACO has been recognized as the global governing body for Olympic kickboxing worldwide. We have applied to the United States Olympic Committee, and we expect recognition and national governing body status by the end of the year. After USOC recognition, we will be conducting qualifying events for future Olympic Games. WACO Team USA Kickboxing holds several events throughout the year at the local, regional, and national levels. We use these events to compile teams for international competition. We send our teams throughout the world, and we bring in teams from other countries to compete here. As one of the largest states in the Union, Texas is extremely important to us. There are many amateur kickboxers in the state of Texas who currently must travel out of state to compete in WACO events. We believe that holding Olympic-style kickboxing events in Texas will not only benefit the fighters, but will also benefit the state. I can envision thousands of fighters from all over the world coming to Texas to compete in a WACO World Championship. The rules that were adopted by the International Olympic Committee and the World Games Association are for full contact, low kick, and K1 styles. Our full contact rules are similar to the rules you currently have in place. However, the state of Texas does not have low kick or K1 rules. Most of our fighters compete in K1, and low kick is used by less experienced fighters who are working themselves up to the K1 level. We are requesting that our full contact, low kick, and K1 rules be adopted and approved by the Athletic Commission so that promoters in the state of Texas can conduct WACO Olympic-style kickboxing events. The future of Olympic-style kickboxing is bright, and we believe that the state of Texas should play a large role in this exciting trend. Thank you for your attention, and I look forward to speaking with you about this in the future.
Mr. Henninger, thank you for your time. Thank you for your information. It's always exciting to hear about new stuff, so appreciate your time.
Thank you, sir.
All right, up next we have Ms. Lily Benitez.
Ms. Benitez, can you hear me?
Yes, I can.
Okay, I'm gonna read some instructions to you. Just stand by for a second.
Yes.
Thank you for being here. Please say your name and who you represent. You have 3 minutes to speak. Please understand that commissioners are not allowed to ask questions or engage in a discussion with you about anything that is not specifically on our agenda. Please also understand that the commissioners cannot hear any information about any complaint or enforcement case because they may ultimately be the decision maker in the case. Do you understand, Ms. Benitez?
Yes, sir.
Okay, you have 3 minutes. Go ahead and go.
Good morning, everyone. TDLR, I just want to, my name is Lily Benitez. I am the founder and director of Bladecraft Barber Academy in Dallas, Texas. And first of all, I just want to take a moment to thank the TDLR staff and team for, protecting the different trades that we have here in the great state of Texas. And so I just want to say thank you because I feel like it can be a thankless job at times. The main purpose of my public comment this morning is in having a Barber Academy for 7 years that has survived through multiple crazy situations in the past few years. One of the things that is a threat to our industry comes from the confusion of the different changes we've had. So for example, the programs have been reduced by a third from 1,500 hours to 1,000. And then one of the most recent changes was it's no longer required to have an instructor's license to be able to teach either cosmetology or barbering. So my concern with, the deregulation of that particular license isn't necessarily from, just a personal preference. My concern with that has been the amount of students that I've had come from other institutions or other programs where they're not being taught how to pass their written exam or their practical exams. Also, the Department of Education has found that 8 out of 10 of their top default institutions come from cosmetology and barbering, and I think that just looks poorly on our industry. I would like to ask that we use our PSI written and practical exam grades to be able to create either like a baseline average pass rate that all of the schools have to be held to, and then if a school is in default of that they have maybe a 90 to 120 day plan to be able to increase those scores. I'm happy to meet with anyone on further details on that, but I just think we have access to this data. We've had it for years and we're just not utilizing. I think that it's important to keep the schools accountable to our students and making sure that they're able to successfully pass their written and practical exams. Thank you for your time.
Ms. Benitez, thank you for your input. That's great to hear. I appreciate your time and efforts.
Thank you.
Up next, we have Mr. Michael Moats.
Mr. Moats, can you hear me? Mr. Moats?
Can you hear me?
Yes, I got you. So I'm gonna read you an instruction, stand by.
Okay.
And then you have 3 minutes, okay, Mr. Moats?
All right, sounds good.
Okay, you might want to turn your volume up a little bit. I can barely hear him, so.
Is that better?
That's a lot better, yes. Thank you for being here. Please say your name and who you represent. You'll have 3 minutes to speak. Please understand the commissioners are not allowed to ask a specific question or engage in discussion with you about anything that's not on the agenda. Please also understand the commissioners cannot hear any information about a pending complaint or an enforcement case because they may ultimately be the decision maker in that case. Do you understand me, Mr. Moats?
I do.
Good, you have 3 minutes. Go ahead and go.
All right. Good morning. Many of you know me. My name is Michael Moats. I am currently advocating within the Behavior Analysis Advisory Board to get some changes made. I am currently involved in civil litigation with the department on multiple issues related to, being required to associate with different organizations in order to be licensed, specifically organizations that certify individuals who shock children with autism. Not only am I concerned about that piece of it, but I also am concerned that rules are changing day by day. For example, between now and the last meeting, there was a rule change made so that videos or recordings could not be shown to the commission. That was a rule that was created between this meeting and the last meeting that you guys had, and it was not done through the rulemaking process. So that is a grave concern also, that rules are kind of changing without following the rulemaking process. But I just, again, want to be transparent, and I feel like I've been pretty transparent throughout this process that I am going to be filing a notice of non-suit to close out this litigation and refiling in the federal courts. And I plan to ask them to strike down the licensure law for behavior analysis as it relates to the requirements that you have to be forced to associate with a corporation, one corporation, in order to be able to practice. I'm licensed in 4 states, and I'm also licensed in 2 states as a counselor. And the reality of it is have to be forced to associate with this organization that again, engages in that practice or not engages in that practice, but they certify people who shock children is a big concern. So thank you guys for hearing me out, and y'all have a great day.
Thank you, Mr. Moats. You have a good day as well. Okay, that's it.
Yes, sir.
Last one. All right, item E, we're gonna go into executive session, so let me read this out to you guys and appreciate your patience with us. We'll go down to executive session to consult with our attorney in section 551.071 subsection 1 and 551.071 subsection 2, the government code. The time is 8:47. Mr. Bowman, how much time do we need?
About 20 minutes or so, I would think.
So let's go to 9:05. Is that fine? We'll go 9:10. 9:10. After the executive session, we'll take a break and come back at 9:10 and pick up when in action on the executive items and begin the contested cases. All right? All right. It is 9:11 and we're back in session. We're back and there was no action items from our executive session items, so we're going on to commission action, which is item G. Electronic signature, I take a motion. Accept electronic signature.
I'll make the motion.
Second. All in favor, say aye.
Aye.
Opposed? Motion carries. Item H, Hammond, you read it. You ready?
Yes, sir, I am.
Okay, and Dr. Weston, I know that you chaired this subcommittee, so thank you for doing it.
Oh, well, I tell you what, it was an honor.
All right, Hammond, you have the floor, sir.
All right, sir, thank you. Mr. Chairman, Commissioners, my name is Henry Bacon, Chief of Staff. Before you today is discussion and approval of the agency's strategic plan for fiscal years 2023 through 2027. And before I continue, I just want to defer to Dr. Weston as he led up our work group for the strategic plan, and then I'll offer some closing comments on it.
Well, I just, also Commissioner Callis and Commissioner Snyder on this review committee with myself. I just want to give my hand applause to the staff. They did a yeoman's job. If everybody knows, TDLR is the premier agency within the state of Texas. We have the most licensees. We cover the most ground. They set up about 5 area meetings across the state so that every licensee had an opportunity to be able to come and talk and visit. And our primary goal has always been to be transparent and to provide the best service for both the citizens of Texas and for the licensees. And I think we do a good job of that. Even and his team, it's an excellent report, and we were kind of under a time crunch, and everybody was burning the midnight oil trying to get this thing out. And I hope it meets with everyone's approval.
All right, sir, Dr. Weston, thank you. Mr. Chairman, I want to just point out a great observation that Christina Kaiser noted in our strategic plan. The prevailing theme of this plan from the last cycle is that it's a reflection of the commission and the department and its incredible hard work, especially for the past 2 years during COVID, shifting to work from home, now coming back to the office. This plan is a vision and a testament to the staff who put in a lot of hard work and a lot of tireless hours. So I thank our staff for doing the work that was expected of them. We had around 21 teams working in various parts of the strategic plan. As Dr. Weston noted, we had several external sessions throughout the state. We had upwards to around 60 staff in total, maybe a little bit more, working on the plan. And I just want to call out, as we're in the last phase of strategic planning, with it being due next Wednesday, June the 1st, we did a bit of a change to do editing and assembly, and we created a chief editor team. And that team was led up by our PIO, Tila Mange. She did a phenomenal job, and with her staff, putting this together for you and the department. I also want to thank Doug Van Pelt, our communications specialist in OSC, Charlotte Melder, our RPM director, Ron Foster, our enforcement director, Karen Berryman, our continuous improvement specialist at OPPM, Jeff Kopis, our government relations officer, Josh Schroeder, our web administrator, and Carnesia Penson, our executive assistant and exec, all of them for doing their work at the very beginning and towards the end in putting this together. There's many other staff I could thank, but I just want to call out this team because last week would not have been possible without them heading into next week's deadline. So we request the commission's approval of the strategic plan, and I'm happy to answer any more questions you may have.
That's Hammond, great job.
Thank you.
Commissioner, any questions?
Just want to say thank you for everybody that had a hand in this. Is an incredible document. They did a good job.
Good job. You did the impossible. You made Dr. Weston look good. Great job.
Happy to help you.
Happy to help. All right, we appreciate this.
Mr. Chairman,
I think I pick on him or you, one of the two.
Mr. Chairman,
I think I'm, yes, sir.
real quickly, what we're asking for is the commission to be able to approve. There are still some minor edits that we have to make. We're still in the process of finalizing. We have until June 1, but in that time frame, we're still kind of going through and kind of massaging the document itself.
Right.
So we're simply asking for the commission to approve the contents of it, the message that's being delivered. and still allow us to make just the minor modifications that we need, for kind of getting the document finalized and ready for submission next week.
Well, I know you and commissioners, I need you to make sure you're aware, this is a very much a living, breathing document. So when session gets in, probably just throw this out the window and figure out what we're gonna do with the ones the legislature decides.
Yeah.
But the effort was, and this is to be commended, so.
Yeah, we've kind of taken a different approach this year, but I actually tasked Hemet to head this up, and he picked a great team, and we modified the way we approached the strat plan this year, as we've done in previous years. But as you can see, it's still a well put together document. They've done a great job with it, and so I do commend Hemet for heading this up and spearheading it. And David Gonzalez was kind of the co-pilot or the vice chair. I'm not sure exactly what he called it. But David contributed also. So they've done a really great job with this document.
All right, anything else? Any other comments? I'll make a motion.
Now I'll make a motion that we accept this with possible future edits for the final deal by June 1st.
A second.
All in favor, say aye.
Aye.
Opposed? Motion carries. Thank you, Emmett.
Thank you, sir.
We're on to minutes. Commissioners, you have a chance to look at the minutes. Any comments, or I'll take a motion?
I make a motion to accept minutes.
All, second, all in favor?
Aye.
Motion carries. All right, Sharon. I think you're up. Personnel name. You had an awesome chair, by the way, didn't you?
We did. It was fabulous. Best committee. Thank you, Chairman. My name is Sharon Hamoya, Human Resources Director and Employment Council.
And I'm Charlie Edmond, Deputy Director of Human Resources and Employment Council.
Today, we're seeking approval from the Commission for revisions to the TDLR Personnel Manual. We presented these revisions to the HR Commission Work Group on May 2nd, and we sent the revised policy to the Commission as a whole last week for review. Our revisions in this policy include legislative updates, audit recommendations, and general revisions based on current practices. There are also some changes to the ethics policy, which will be presented shortly by Brad Bowman from General Counsel.
It was a very robust document, so I'm just going to highlight it. I'm sure that you all had the opportunity to review it. And in your guide, we outlined what was legislative, what was recommended by audit, which although not required for us to do, ensures that we're aligned with best practices. So I will highlight some of the general revisions that were made to ensure that we are employing best practices ourselves and doing things in a way that's effective for our employees. The Section 5 talks about a change to the FMLA policy, which we eliminated a provision that prevented employees that are employed by TDLR simultaneously, spouses, partners, to have a total combined week of 12 leave. That is something that statutorily we are allowed to do, but we felt no longer benefited our employees. Of course, when the FMLA was first passed, it was a practice many employers did, and now we kind of have moved from that, realizing that that should be open to both employees. And so any spouses or partners employed by TDLR that are eligible for the 12 weeks do not have to have that combined total. We also require a documentation from our veterans to receive veterans mental and medical health leave. We made that update to the leave section. However, we did want to ensure that you all know that's definitely not an inhibition. We work with our Texas Veterans, our TDLR Veterans Association, to ensure that we can not inhibit them in any way by having that requirement, and they have continued to utilize that leave. Mike was generous to increase the tuition reimbursement from $250 per semester, a total of $500 per fiscal year, to $500 per semester and $1,000 per fiscal year, which is still well within statutory guidelines. We also made substantive changes to our work schedule policy just to reflect current practices. For instance, leave under inclement weather, which was something that previously was handled in a certain way, but now we have a remote workforce that can work remotely if the school districts are closed. The last big change that was made, that was a sort of a robust change that was not legislative or audit recommendation, was to our grievance procedures. And that was really made to ensure that our policies reflected what our practices were and clearly delineate kind of 3 avenues that employees have to procedures. The remaining changes that are highlighted will be the legislative audits or the legislative updates or the audit recommendations that we wanted to come into conformity with following an audit by TWC. And if you all have any questions, then you can feel free to ask them. Otherwise, we would ask that you approve the revisions as they are.
After Brad has an opportunity to discuss his ethics.
Mr. Bowen.
Statement.
Mr. Chairman, Commissioners, Brad Bowman, General Counsel, I'll be very quick. So while HR was undertaking this project to kind of revamp the personnel manual, we took on the ethics policy to kind of rewrite that. That's a part of the personnel manual. Doug Jennings took this on as a project, and the goal was to make the ethics policy for our employees a little more clear, a little more straightforward, to use plain talk, things like that. We're not really making substantive changes to it. It's based on state ethics laws and requirements. But that was the goal, to kind of make it a little more clear to our employees. And in doing that, we use some specific examples. So some do's, some things that are prohibited, some things that are not prohibited, to give some clear guidance to our employees. So that's really the effort, and your approval of the personnel manual would include incorporating those changes to the ethics policy. And I'm available to answer any questions.
Commissioners, extraordinary in the sense that post-COVID, this is dynamic. It's never been, right? I mean, typically they're pretty normal, dot the i's, cross the t's. But now we've really taken an effort into understanding what virtual means and how to engage, how to make people safe, but also productive in every aspect of that sense. So that's important because we don't live in a world. I think I did 0 Zooms pre-COVID, right? 0. So I do 4 a day. But that's good. We just need to make sure the personnel matters follow suit. So no more than the TDLR is affected in the personnel. And our greatest resource is our people. Any comments, questions?
I just want to, how many of our employees are still working from home? Is there a round number?
Currently, we do have a return to work policy for the majority of staff. So we have always had some home-based staff. And now our customer service division is completely remote. I would say probably approximately 70% of staff are coming back in some form. Some have never left. So some have continuously been in the office and have maintained a presence, but we are definitely getting the feet wet and have been coming back for a few months now to get people used to dusting off their cubicle and getting back in the office and having those interactions that we've missed during the COVID times.
That brings up another question on customer service, if it's all remote. I know a couple of times I had to drop off something at the office, and you have to kind of call ahead. And there was a couple of licensees out there that were trying to figure it out. Have we gotten, I mean, a lot of people don't go to the web first, I'll be honest with you.
Absolutely.
I'm probably one of them on some things that I probably shouldn't admit in public, but I just want to make sure that from a standpoint of licensees, if they're not real computer literate or have that ability and they show up and the door's locked, do they have a way, do we even have a phone that's down there that they can call in now that somebody's back there?
We have signs directing them to the number that they can call to get assistance. We are currently reviewing our front desk in our lobby area that is being utilized by the governor's office. And we're trying to work with the governor's office and the Capitol Complex DPS to remedy that. And I don't know, Mike, if you have anything you want to kind of add.
Commissioners, as Sharon was mentioning, when COVID began, we worked a deal with the Governor's Protection Detail, and they're using the lobby to be able to do COVID testing for all of those that are visiting the governor, the speaker, lieutenant governor, and the attorney general. And so anybody that has an appointment to go visit them, they have to go through this facility, through the lobby area to get COVID tested before they can head over to be able to meet with them. They're still there. The number of tests that they are now performing have dropped dramatically, but they're still there in the lobby. I've been in communication with the chief, Rudy Resendez, who's the heads up the Governor's Protection Detail. And we're now talking about the possibility of where they can move within the E.O. Thompson building to still be able to have a presence for testing, but allow us to be able to take that lobby back and begin to start opening up as we're talking about. So that's still a conversation piece that we're having. The conversation gets kind of cold as the numbers go up. And when the numbers went down, we started having the conversation a lot more heavily. Well, now the numbers have gone back up to about 13%, and they're increasing again because of the BA2 variant, the BA2.12.1 variant that exists. So we're still having this conversation with them, but it's cooled off a bit because now they have more people come in for testing because of that. So we're still working through that and trying to find a place that we can actually have. But yeah, the number that's on there allows them to be able to talk to somebody, and then somebody from licensing or somebody that's in the office can come down and get the information that they have, whether it's an application, a check, whatever it is. We can still get to that.
But I mean, there's always, somebody calls that number, they always get to talk to
Yes.
somebody. It's
Yes.
not a 10-minute hold.
Yes.
or
Correct.
15 or whatever.
Correct.
Good question.
And we've had that instance recently where someone was actually on site. And so our customer service division is very effective at routing those calls in a certain manner. Someone was on site, we were notified of it, they were expressing some concerns, and we were made aware of it. And so we have staff that are on site that can go down to assist, and that does happen,
Awesome, thanks.
Any further questions?
I can tell you that there's been a lot of work put into this personnel policy. We have to give kudos to Charday and Sharon because they spent a lot of time on this document. It was a few years coming because there's just been some legislative changes that have occurred. And even though they may have been slight, they still impacted the personnel policy, and it's just a matter of catching up. So this document that you have brings us up to date where we need to be. So.
All right, I'll take a motion.
I'll make a motion.
Second. All in favor, say aye.
Aye.
Opposed? Motion carries. Sure. Want to let Christine know that we've got a rogue voice.
Somebody broke out.
Okay, so personal manual, now we're gonna go to contested cases, which is item K. Is everyone, okay, good. If anyone is appearing in person for a case today, we'll call you up when your case is announced. If anyone is appearing by video conference today after the case, staff will provide them with information on how to connect to this meeting and will bring them into the meeting when they announce the case. I guess we're gonna go to item, or sub 1, which is Juan Perez. And Jessica, good to see you. So, is he virtual or is he?
Yes, sir, he is virtual. He's
Okay.
Calling in by phone. And we
Mr.
do
Perez,
have
can you
him
hear
on.
me?
Yes.
Okay, good. This is Chairman Figueroa. I'm gonna read you some instructions, and then after those instructions, I'll make sure you understand, and then we're gonna hear from the prosecutor, okay?
Okay, thank you.
Okay, we'll hear from the prosecutor first, then you can go. You'll have an opportunity to speak. Make sure you speak clearly, say your name and who you represent. Each side will have 5 minutes to speak with up to 3-minute rebuttal if needed. Please understand the commissioner can only hear information in the record from the case that was heard at the SOA. So you must limit your comments to those matters that were presented at the SOA hearing. Do you understand, Mr. Perez?
Yes.
Okay, good. If you have any questions, you're welcome to ask me. All right, Jessica, beautiful.
Thank you. Good morning, Commissioners. My name is Jessica Hurtado, and I'm a prosecutor in the Enforcement Division. The ALJ recommends that Juan Perez's application to renew his apprentice electrician license be denied and that his license be revoked. Mr. Perez has an extensive criminal history going back to the late 1990s. In 1998, Mr. Perez was convicted of failure to identify, a misdemeanor, and forgery and theft from person, both felony offenses. While the court originally placed Mr. Perez on probation for his felony offenses, his probation was revoked in 2001 and he was sentenced to 6 months in prison. In 1999, respondent was convicted on 2 separate occasions for criminal trespass. And in 2000, respondent was convicted of unauthorized use of a vehicle, a felony. And he was placed on 5 years probation. Then in 2001, his probation was revoked when he was sentenced to prison. In 2000, Mr. Perez was also convicted of misdemeanor theft, and in 2002, he was convicted of failure to identify and theft when the respondent was caught shoplifting. In 2004, Mr. Perez was convicted of burglary of a vehicle and placed on community supervision. Later, the court revoked his supervision and sentenced him to 34 days in jail. In 2005, he was convicted of theft and evading arrest. In 2006, he was placed on deferred adjudication for indecency with a child by sexual contact, a felony. However, his supervision was again revoked in 2007, and he was sentenced to 5 years in prison. In 2007, respondent was convicted of criminal trespass, and in 2013, he was again convicted of theft. In 2014, he was convicted of failing to register as a sex offender and sentenced to 3 years in prison. Mr. Perez was released from prison in November 2016. And despite this extensive criminal history, in May 2018, the department took a chance on Mr. Perez and granted him his apprentice electrician license. Then, in October 2019, while licensed, respondent was convicted of a misdemeanor theft after he and another individual, whom Mr. Perez referred to as a friend, under the cover of night, entered the backyard of the victim's home, removing the victim's property that they found there. The victim was alerted to the theft when he was awakened by a noise, and he contacted police. The respondent and his friend were located by police in the parking lot of a drive-through restaurant, attempting to sell the property to an employee of that restaurant. And when Mr. Perez applied to renew his license in April 2021, he answered no to the criminal history question, despite having been convicted of theft in 2019. Respondent's written explanation of the offense stated that he made a mistake in believing that his friend was removing property from his own home. Mr. Perez testified at the hearing that he believed the property was located at his friend's grandparents' home, but later stated that his friend was actually homeless at the time. In analyzing this case, the ALJ concludes that respondent's 2019 theft is directly related to the electrician occupation as a crime against property. The ALJ did not find Mr. Perez's explanation of the offense to be credible. That property was removed from a residence in the middle of the night, and an attempt to sell it was made soon after. And additionally, the ALJ found the respondent's testimony was internally inconsistent, at times referring to his belief that the property was located at his friend's home, and at times referring to his belief that his friend was in fact homeless. Mr. Perez explained that his wife, whom he was separated from at the time of his most recent theft, was the one who renewed his license and answered the criminal history question no, because he had not informed her of the 2019 conviction. The ALJ notes that the most recent theft occurred only about 2 years ago when respondent was 47 years old. While the ALJ notes that Mr. Perez seems to have had an isolated slip-up since his release from prison, however, in light of his extensive past criminal history and given his most recent offense, the ALJ concludes the respondent is not currently fit to be licensed as an electrician. Further, the ALJ concludes that respondent is also not a good candidate for a restricted license, and therefore the ALJ recommends that you deny Mr. Perez's renewal application and revoke his license. I ask that you adopt the PFD as written, and I'm available to answer your questions. Thank you.
Any questions for Mr. Shaw? Thank you, Jessica. Okay, Mr. Perez, can you hear me?
Yes, I may say cancer.
Okay, I want to make sure you understand, we cannot hear things that weren't stated in that SOA hearing. You're gonna have 5 minutes. Do you understand, Mr. Perez?
I'm sorry, say again?
We cannot hear anything that was not stated or heard in that SOA hearing that you were in. So make sure you contain your comments to that. Do you understand what I'm saying?
Yes, sir.
Okay, you got 5 minutes. Go ahead and go.
Okay, sir, my name is Juan Carlos Perez. As a youth, in my early 20s, I chose a different path for my life, and I made a lot of mistakes, and I was homeless for about 6 years. I did a lot of things that I regret. When I finally chose to get my life together, I went back to school at a college for my apprenticeship electrician license. Before I sat down with the college professors, I asked them, the people that recruited me for college, I asked them if my criminal history would ever affect me in getting my license. Otherwise, why would I go to school for this if I wasn't going to be able to obtain a license? they assured me that they had even murderers granted license for electrician. So therefore, I committed myself to bettering myself and getting my degree and my career in electrician, which is something that I learned that I love and I take pride in. And so date where the lady is saying that I committed that misdemeanor theft. There's a lot of things that she's not saying that are on the proposal for decision. I never said that the guy was homeless. I said that I used to be homeless. Okay, I said that I had left my home because my wife and I were having problems. My wife suffers from depression, bipolar, so sometimes she gets unbearable. So I had left and I decided to go stay with a friend. Okay, the so-called other gentleman that I chose to give to help with pertaining those getting those tables was not the same individual. It was a different individual. Okay, so it's not the same guy. I was trying to be as cooperative as I could with the police when they came upon us. The guy that I was helping, that I thought was my friend, he ran from the scene and I stayed trying to correct whatever was happening with the situation. I gave the police the guy's name. Everything that I had about him, information that I had, I gave, and then I went to jail. I was going to be enhanced, which means I would have had a state jail felony if I did not take a plea for a misdemeanor. And that's the only reason that I pled out and pled guilty. Okay. Upon getting out, my life started getting back together. I was going to get my job as an electrician again with my boss, but he required that I get my license. Okay, which is when I filed for this application to renew my license and took the class online. My wife helped me fill out the application because I'm not too computer savvy. When she filled out the application, she signed when they asked about my criminal history and if I had anything new come out since then, she answered no. As soon as that happened, I got a letter in the mail from TDLR saying that I had lied on my application. And then I confessed to my wife that I had indeed had a misdemeanor. And this is just a lot for me. Hold on a second. So here I am today at your feet, trying to get my license back. My wife and I, my family and I, we've moved forward. We're already in the closing phase of getting our new home. Not having my license has not stopped me from growing and from seeking better things for me and my family. The only thing that not having this license has done for me is stop me from bettering myself and being able to achieve my journeyman, maybe my master's, and become my own business owner. That's the only thing not having this license has done for me. I ask that you please consider my history now and not my past. Thank you.
Mr. Perez, thank you for showing up. Thanks for your comments. Commissioners, any questions for Mr. Perez or Mr. Tyler?
Thank you.
No?
No.
Mr. Weston? Okay. I'll take a motion then.
I'll make a motion that we accept the PFD as recommended by the city.
There's a second?
I'll second.
All in favor, say aye.
Aye.
Opposed? Okay. Mr. Perez, do you understand the staff will follow up with you? This is not the end of a trail. They'll get back to you with other options you may have. Thank you for being here. Thank you for your honesty, and we wish you the best. Okay?
I didn't quite hear the outcome.
We passed the motion PFD to deny the license, but this isn't the end of the trail. There'll be a staff that will follow up with you to see what your next options are be. But we appreciate your honesty and you showing up today. Okay?
Thank you.
All right. We'll make sure somebody follows up with you. All right. I'm two, Hollenbeck, and Mr. Tyler. Go ahead. All right, is Hollenbeck here or virtual?
Hollenbeck is virtual.
The attorney is also.
Yes, the attorney is present, and I don't see him. I see his shoulder.
Is that the attorney? What's his name?
Tom McClellan.
Tom, can you hear me?
He's on mute.
Can y'all hear me?
Yes, sir. Can you just pronounce your last name for me, Tom?
Yes, sir. McElroy.
Maclay, Mr. Maclay, thank you. This is Chairman Figueroa. I'm gonna read some instructions to you, and then we'll
Yes, sir.
proceed, okay? All
Yes,
right.
sir.
Is your client on the line?
Yes, sir. She's sitting next to me to my left, and Mr. Saunders, co-counsel, is to my right.
Okay. I want you to know that we haven't had a hearing, a SOA hearing in these two cases. So I'll make sure, typically I would tell you the comments restricted, so I'm gonna let this, give you a little latitude here, okay? So I'm gonna read this instruction to you. And please stick to the facts if you don't mind. We'll hear from the prosecutor first, and then you'll have an opportunity to respond. Make sure you speak clearly, say your name and who you represent. Each side will have 5 minutes to speak and up to 3 minutes for rebuttal if needed. Please understand the commission can only consider information that is in the record from the case heard at the SOA hearing. Again, I want to state that the reason we want to hear you is we just want to make sure to stick to the facts of the case. So if you limit your comments to those matters, that would be great. All right, you understand?
Yes, sir. But I'd just like to correct the record. We did have a hearing back in December, and the commission tabled the matter.
It wasn't a SOA hearing.
Yes, this is Brad Bowman. I think he's referring to the commission.
Right, it was a commissioner meeting, but yeah. It wasn't a SOA hearing, but yes, if you don't mind, and we realize the extraordinary nature of what you're gonna talk about, but I just wanna make sure that we don't go down any rabbit trails, okay?
Yes, sir.
Okay. All right, go ahead.
Thank you. Jessica Hurtado, Enforcement Division. I ask that you adopt the PFD as written and revoke Jennifer Hollenbeck's massage therapist license as required by law. This case was decided without holding a hearing based on the department's motion for summary disposition. Ms. Hollenbeck was represented by counsel who filed a response to the department's motion on her behalf. After reviewing the arguments of both parties, the ALJ determined that there was no genuine issue as to any material facts in this case, and that the department was entitled to a decision in its favor as a matter of law. The ALJ issued a PFD recommending revocation of respondent's license, and respondent's counsel filed no exceptions to that PFD. In May 2000, the Department of State Health Services issued respondent a massage therapist license. Then, in 2001, respondent pled no contest to the offense of public lewdness. The court placed respondent on deferred adjudication community supervision for 6 months, and respondent continued to renew her license with DSHS until that program was transferred to the department in 2017. In April 2020, respondent applied to renew her license, and the department learned of her prior deferred adjudication for public lewdness. Based on this information, the department sought revocation of respondent's license. This case involves the mandatory license revocation provisions in the massage statutes that have been in place in roughly the same form since 1987, almost 13 years before the respondent was ever granted a license. These same statutes have been considered in previous cases before the commission, where the commission has consistently and uniformly applied these statutes, which makes an individual ineligible to receive a license and requires that any license they hold be revoked if they enter a no contest plea to or receive a deferred adjudication for a sexual offense. Public lewdness is an offense that is found in Chapter 21 of the Penal Code, titled Sexual Offenses, and the elements of public lewdness include knowingly engaging in an act of sexual intercourse or sexual conduct in a public place or in the presence of another who will be offended or alarmed by that conduct. The ALJ determined that public lewdness is a sexual offense requiring license revocation. Like in the Miranda Bloom case, which also involved the public lewdness offense, the respondent's license must be revoked. Despite our obvious sympathies for the respondent, the law leaves us no discretion in this case. I ask you to continue our consistent application of the massage laws and adopt the PFD as written. and I'm available to answer your questions. Thank you.
Any questions for Jessica? Okay, Counselor, you have 5 minutes. Go ahead and go.
Yes, sir. Thank you, Commission, and thank you for granting our request for a Zoom hearing. I know that I'd like to be down there live in Austin. I represent Ms. Hollenbeck, my co-counsel. Mr. Saunders is here as well. I'm going to speak briefly to the facts. Ms. Hollenbeck was licensed back in 2000. She did receive or enter a no-low contendere to public lewdness in 2001. She was already licensed. Now, at the time, she was a young woman in her early 20s, and she was working to try to make money, living on her own. She was at a, as they call them, a gentleman's club, but we all know they're strip clubs. She was upstairs and got called downstairs to the office, and there were two plain uniform officers who gave her a citation. Any court record has been destroyed other than her plea of no low. She has no idea what she did. I'm pretty sure there was an undercover officer upstairs, and had she done something bad, like massaging someone, oral sex, or sex, there would have been a prostitution charge. She has been licensed every year until they fingerprinted her last year. This woman has been a massage therapist, and I'm not going to mention names, for the Dallas Stars, the Cowboys, both Bush administrations, the Obama administration, and now the Biden administration. The prior hearing I just heard, unfortunately about Mr. Perez's past, seems like he's gotten into a little bit of trouble over the years. She has one charge back in 2001 when she was young. That's it. No parking ticket, no speeding ticket since. The commission licensed her or renewed it every year until it went to TDLR, I believe, in the mid-2015s. It was 17, it was biannual since then. Now I'll let Mr. Saunders, my co-counsel, briefly talk about the law so we don't use up all of our time.
Good morning. I will try to be brief, which is very difficult for an attorney. When it's stated that the law is unambiguous, I believe that is incorrect. And I do not believe the law applies to renewals. It only applies to her initial registration. As stated, she was licensed before she pled no contest. The law at the time clearly says she would be ineligible for registration. She had already registered and was licensed. As previously stated, it was said that the law is almost the same since I believe it was stated in 1987. That's actually not correct. In my opinion, the law was changed in 2005, it was changed in 2017, and in the current version. In 2005, the word registration was changed to license, so she'd be ineligible for her license. But when she was licensed, it was for registration. And so that's why she was renewed every year, because the law only applies to her original licensure. So if she had pled no contest before being licensed, the law would have applied. She pled no contest after being licensed. And to prove that it only applies to renewals, and that's why the TDLR renewed her every single time, if you look simply at the questionnaire, the criminal history questionnaire that the TDLR provides massage therapists, it clearly says, for renewals, did this probation or conviction occur since your license was issued last? Yes or no? So for renewals, I'll restate that. Did this probation or conviction occur since your license was last renewed? So if you had had, like the previous case, the gentleman had, was licensed and then had conviction subsequent. She did not. The cover letter to the criminal history questionnaire to prove that this law only applies to renewals and not her legally original license, it says, this is the cover letter from the TDLR dated July 15, 2020 with the attached criminal history questionnaire. Quote, if you have been convicted of a crime or placed on deferred adjudication, complete and return a separate criminal history questionnaire for each conviction or deferred adjudication. If your application, and I stress this, if your application is
Counselor, can you give me a second here? I need you
Yes,
to
sir.
wrap it up. I'm gonna give you another
This is my
15
last-
seconds. Wrap it up.
Yes, sir.
Go ahead.
So the rest of the question is, if your application is a renewal, only return CHQs, criminal history questionnaires for convictions since your most recent license was issued. So the law only applies to renewals, and that's why the TDLR continue to renew it.
Thank you, Counselor. Appreciate it. Any questions, Commissioners?
Mr. Saunders, can you hear me, sir?
Yes, yes, sir.
So you said that the TDLR had continued to renew her. It's my understanding that the first time she came up for a renewal is when we denied her because we received that program through the Department of Health and Human Services. Is that correct?
No, sir, she had been renewed annually from 2000 to 2008. And then from 2008 to 2018, she was renewed biannually. We've been renewed a total of approximately 12 times.
Yes, sir, but the TDLR has only received that program 2018.
2018.
17.
The Department of Health and Human Services had it prior to that. So on her first renewal under TDLR is when we caught it.
They did renew her once since it was transferred over. Yes, sir.
Yes, sir.
And what year was
I
that?
can speak to this.
Hang on, Counselor. Go ahead, Jessica.
Yes, so there was a renewal in July of 2018.
It was under when we first got the program. Okay. Okay. There was one renewal when we first got that program. Okay, thank you, Counselor.
Sir, she was also renewed in 2020 is our understanding. She was renewed twice.
She was,
Under TDLR twice.
Okay.
that's correct. I mean, the license was renewed, but then the case was opened at the same time in 2020. But the license was renewed pending this
Same time. Pending this.
case. Yes,
So
sir.
that she was allowed to continue to work.
Yes.
Okay, okay. All right, good questions. Any other questions?
May I add one thing, gentlemen and ladies?
Again, we'll give you about 30 seconds, Counselor. Go ahead.
If this woman was a problem and she's been doing several presidential administrations and cabinet members, don't you think the Secret Service would have prevented her from doing it?
I appreciate the comment, Counselor. Thank you. All right, Commissioners, anything else? Okay, we realize with the plea that you're making, Counselors, we realize the understanding, this is a process. It's not a process we like, not a process that we're a fan of, but it's a process. And we're gonna try to move the process along to allow your client and those that are also in the same situation to move forward through the process, to maybe have either some statutory relief or some other judicial process. So I just want you to know that.
Yes, sir.
Okay. Commissioners, I'll take a motion.
Make a motion that we deny the request for licensure.
Second. All in favor, say aye.
Aye.
Opposed? Okay, motion carries. Counselor, I cannot state enough, it is a process, and it's not a process we're a fan of, it is a process. We encourage you to fully vet that process, and we'll see where it stands, and hopefully we'll see some remedy, okay?
Yes, sir.
Thank you.
Thank you. Okay, item 3.
Oh, wait.
Yeah, we're done, we're done. We're done now. Ms. Perillo, right? And, okay, go ahead, you can go ahead and take. And, all right, so you've heard me read this several times, so I'm gonna say this all, but
Yes,
kind of
sir.
sound in my voice, if you don't mind, Counselor. Good to see you guys. Jessica, you go ahead.
Thank you. Jessica Hurtado, Enforcement Division. Trevor Thielen handled this case before SOA. However, no hearing was held because after we filed a motion for summary disposition, the ALJ decided there were no factual issues that could affect the mandatory outcome of this case. We recommend that you accept the ALJ's recommendation and revoke Linda Ferrillo's massage therapist license and deny renewal because the law requires it. The statutes here, again, involved are the same massage industry statutes you've considered in many commission meetings over the years and in the previous case. In each of these cases, the department's evidence of a particular type of criminal plea or judgment activated a massage law which requires you to revoke a massage therapist license. In each of those cases, that same evidence activated another statute that makes each of them permanently ineligible for a massage license. In each of those cases, the DSHS unfortunately ignored or misinterpreted clear direction from those laws by granting and renewing some massage therapist license where the law did not allow them to do so. And now that the industry is regulated by TDLR, this commission has followed the clear direction of those laws in other cases and would believe that you have no discretion other than to do so again in this case. The massage statutes are clear. Ms. Carrillo hasn't been eligible for a massage therapist license since 1992, when she pled guilty to and was convicted of prostitution. Despite this plea and conviction, DSHS granted her a license 4 years later in 1996. The ALJ agrees that you have no discretion and granted the department's motion for summary disposition because no hearing was necessary to resolve the legal issues involved in this case. You should note that the respondent did not file a response to the motion, as was her right, and that in her exceptions, she even acknowledged that the current law bars her from further practice of massage therapy. And I urge you to keep in mind that these laws are mandatory for the department and for you, regardless of any natural sympathy that may understandably develop. And when you hear about the respondent's passion for remaining licensed, the misguided approach from DSHS in renewing her license multiple times, and the time that has passed since the offense that requires the license to be revoked. We recommend you adopt the PFD as written, and I am happy to answer any questions. Thank you.
Any questions? Okay. Counselor, what was your name?
Jason Danowski.
All right, Mr. Danowski. You state your name clearly and you know the guidelines.
Yes, sir.
5 minutes, go ahead.
Jason Danowski for Linda Ferrillo. Thank you for the opportunity to be here today. It's a little unusual compared to the normal procedural posture in which I've come before the commission. Every time I've come before, we have always asked for either a PFD to be amended or to be accepted. And we're asking for something a little different today. My client is no longer practicing as a massage therapist. As we acknowledged in our exceptions, and the reason we did not file a response or a period hearing is because we agree the law is black and white, and unfortunately it mandates a certain result. However, we became aware that the commission has tabled some cases as in the previous matter. And so what we're asking for specifically today is for the commission to table the matter and allow my client to either surrender her license or let it expire so that she may retire from the field gracefully. And we realize that's a little bit of a different ask, but that's what we're asking for today.
Okay,
And I'm
Counselor,
happy
I'm
to
not
answer any
sure.
questions on
I
the
want to
matter.
make sure I understand. So what you're asking is that we issue a license to her so she may retire.
No, we're asking that the decision on the PFD be tabled, and then in the interim, actually her license is currently expired. In the interim, allow it to expire and then moot the case.
I'm not sure. I mean, Brad, am I able to consider that as a mission? I'm not sure that's within purview.
Well, and Mr. Chairman, this is Brad Bowman, General Counsel. I think what the council is asking is to table or delay the decision in the case. I'm not sure what effect that has on the license, though, in terms of what Mr. Danowski is asking you. I can't really advise you to do anything other than the normal APA process of you got a PFD in front of you and it's rendering a decision based on that. There is even if her license has expired, there's a right of late renewal that extends for some period of time. It's 18 months or up to 3 years. So if we're looking at that kind of delay, that doesn't seem feasible.
Correct. You couldn't deal with that.
So I'm not sure I'm totally clear on the ramifications of the delay here of what's going to happen. But you may want to hear from council, both enforcement.
I'm sorry?
And you may want to hear from enforcement in their position on that as well.
Before we do that, Commissioner, I know that with this issue, it's been, unprecedented in how we do this, right? And we're trying to work around, which may have caused some precedent that we don't want. But I want you to be aware of, as we listen to, I'm allowed 2 counselors to go back and comment about this because I'm not sure. I want to make sure we wrap it up as much as possible. If you have questions, let's dig into it real quick, okay? So let's move forward. Go ahead, Counselor.
Thank you, Commissioner. I think what Mr. Danowski may be asking for is that it sounds like he wants his client to surrender her license, which could be done through an agreed order process. We've done that before in other cases when they've come to you at this stage. And then we can bring it back to you to dismiss it at that time as resolved. That would be one option if that's what would be acceptable to them and to you.
So to surrender the license
Do an agreed order.
through agreed order and then bring it back up in the future.
We could bring it back to you to dismiss it because as resolved through
As
the agreed
resolved.
order.
Okay, I see what you're saying.
If that's what.
Mr. Bowman, how do you feel about that?
Yes, Mr. Chairman, you could do that, and that would just, you would take no action today and let the enforcement division and respondents council work out an agreed order to surrender the license. If that happens, you could just dismiss it at your next meeting.
Are you good with that, Counselor?
Yes, sir.
Are you good with that?
Yes, we can do that.
Commissioners, all questions? You good? Yeah. All right, so we'll take no action on this item right now. Didn't see the curveball coming, so thanks, appreciate that. Woke me up. So we'll let you guys work it out and we can bring it back to the matter. Is that okay, Mr. Bowman?
Yes, sir.
Mike, you good with that?
That's good. Thank you, sir.
Good, outstanding. Great, thank you, guys. Thank y'all.
Well, have a good day. Good to see you in
Good to
person.
meet you.
Okay. All right. I think I went to law school just now. All right. We are in motions for rehearing, right? Correct? Price?
Yes, sir.
Okay,
And what we'll have to do is maybe go on to the next agenda item because Mr. Miller is having connection issues. They're trying to get him back.
you know what? I'm gonna take a 5-minute break, if you don't mind. We'll get you reset, because that way we can get this and move on. I don't wanna have to wait.
Yes, sir, that works.
Okay, so it is 10:04. We'll come back in 10:10, okay? it's 10:13. We're gonna get back and we're gonna go to item motions for rehearing. Jeremy Miller and Mr. Jennings, are you on? Yes.
Yes, Chairman, I'm on. Thank you.
Okay, Mr. Miller, are you on? Are you there?
Yes, sir.
Okay, so I'm gonna read some instruction to you, Mr. Miller, and then we're gonna go from there. We'll hear from the general counsel first, and we'll have you have an opportunity to speak. Please speak clearly, say your name and who you represent. This is a motion for rehearing, which means there's already been a decision made in your case. So we're not here today to re-argue the case. This is an opportunity for you to tell us how we made an error in entering a decision against you. You'll be limited to speak about those issues that were raised in your motion for rehearing. The Assistant General Counsel and you will have each 5 minutes to speak. And if so, we'll need a 3-minute rebuttal. Do you understand, Mr. Miller?
Think so.
Okay, we're gonna hear from Mr. Jennings first, and you'll have queued up. Okay, Mr. Jennings, go ahead.
Thank you, Chairman, and good morning, Commissioners. My name is Doug Jennings, Assistant General Counsel for the Department. The matter before us resulted from a default order in which the Department assessed administrative penalties against the respondent in the amount of $4,000 for unlicensed air conditioning and refrigeration, I'll call that ACR, contracting. Specifically, the Department found that the respondent contracted to perform, and ultimately did perform, the installation of ACR systems in 4 new construction sites. Now, the respondent's motion for rehearing states that the Department has erroneously penalized him for unlicensed contracting, despite the fact that he does not hold a license. The ACR statute is crystal clear on this issue. An unlicensed person may not contract to perform or perform the installation of air conditioning and refrigeration systems. Respondent does not have an air conditioning and refrigeration contractor license and is not even registered as an ACR technician. Therefore, the law is clear that the respondent is subject to administrative penalties, and if administrative penalties in this case, and so therefore we would ask that you deny this motion. Thank you.
All right, thank you, Mr. Jennings. Any questions for Mr. Jennings? All right, Mr. Miller, you have 5 minutes. Can you hear me?
Yes, sir.
Okay, you go ahead and go.
Well, I was working with a company that pulled a permit and had it inspected. I was just a technician for this company. And I am a licensed technician. At the time, I was not a licensed technician because I was not aware that I had to have that licensed technician certificate. So in the time that I spoke to the investigator, he told me all I needed to do was get my license for a technician, and I have done that. As far as the job, it was insured, inspected, and permitted. So I'm not understanding where I'm at fault.
Okay, so Mr. Miller, I think the hearing's already, I guess, so were you there at the hearing?
Chairman,
No,
just
I
to
never.
butt in, there was a default order issued in this case.
Okay,
There was no
I'm sorry,
hearing,
right.
so.
I apologize for the default order. Okay, good. So, Mr. Miller, do you understand what he means by that?
No, sir.
You basically missed it and it just went to the default process. No, that's basically.
I wasn't aware.
Okay, that's.
The only communication I had was with the investigator, and when I spoke to him, I explained everything to him and told him that the job was insured, permitted, and inspected through the company that I was working for. And he said that I needed to get my technician's license to work for a company, and I have done that.
Okay. So, Mr. Jennings, he was notified, correct?
Yes, Chairman. All the proper notices were sent. The notice of alleged violation was sent. The notice of default was sent. The default order was sent to addresses found on our clear reporting system. Also, I just want to note that the investigator collected evidence from the complainant in this matter, showing that the checks, I believe 2 separate checks in the amount of just over $19,000, were written directly to the respondent in this case, not to this, the friend or the contractor that he's claiming he worked with. Additionally, just to give you some background about this case, it resulted from a complaint in which the person that the respondent contracted with complained about faulty work being performed. And so the faulty work and mechanical integrity is not part of the case that was opened against Mr. Miller, but just giving you some general background about the case. So we do know that Mr. Miller contracted directly with the complainant because we have checks and invoices. And so regardless of whether an investigator told Mr. Miller that all he needed was a technician license, it would be true that if Mr. Miller had a technician registration and had worked under the supervision of an air conditioning contractor, we wouldn't be here today, but there was no evidence of that.
Okay, all right. Any questions?
How's there no evidence of that when it was permitted?
Mr. Miller.
I'm
hang
sorry.
on.
I'm sorry.
You need to stay down. I'll let you know, speak in a minute. Any questions for commissioners?
I just want, Mr. Jennings, I got one question. You said all the proper notices that were mailed, sent, emailed. Do we have any record that Mr. Miller received at least one, or knew that this process was ongoing?
I am looking at the notices right now, Dr. Wesson. It looks like some of the notices of defaults, at least one of them was unclaimed. One was not deliverable as addressed. Let's see, the others, one was returned to sender. So we do have, for one of the notices of alleged violation that it was delivered and left with an individual. We sent these to 4 different addresses, just to make sure that these notices made it to Mr. Miller. Again, I would like to raise that, the motion for rehearing really just contests the fact, I think shows some confusion about licensure and how it works and what kind of license is required. And so this is the first time I've heard any claim that Mr. Miller didn't receive notice. And so I'm just having to kind of scramble and look through the notes, but it looks like at least one of the NOAVs was left with an individual at one of the addresses in Waxahachie. One was left at a reception mailroom at another address. One is marked in transit and one was returned to sender. So it looks like at least 2 of the NOAVs were delivered and left with a human being.
All right, thank you.
Again, it's about unlicensed activity, commissioners, is what we're talking about. So it's FYI. Okay. All right, Mr. Miller, I'm gonna give you 30 seconds to make comments before I go to the commissioners. Go ahead.
And I never got any notices. If I would have responded to them like I did to the investigator. I mean.
Okay. All right. Thank you, Mr. Miller. I appreciate that.
Yes, sir.
Any questions?
I mean, I'm thinking if he didn't really get any notices, should we grant a rehearing to at least go through the process again? Or not? That's just no.
I need you to speak up just a minute.
Oh. I mean, I'm just struggling with the idea of doing a rehearing, because he said he didn't get any notice, and we don't really have any record other than we left it with somebody else.
Right. And Mr. Jennings, go ahead. I know you want to make a comment about that in regards to this is about providing unlicensed activity without having a license, right? Basically, that's the contention.
Yes, Chairman Figueroa, and I do want to address. I'm just getting a message from the prosecutor on the case that the first amended NOAV, notice of alleged violation, was delivered to an individual on December 20th, 21. And so it looks like we have 2 deliveries on or about that date of the 4 addresses. So we have 2 that were left with a person and 2 that were not. Unclaimed, by the way, is seen as proper notice because we have sent. A person may want to avoid service by not claiming a piece of registered or certified mail. So from my perspective, and obviously you may differ, it looks to me that service was adequate in this case, and that the penalty was assessed in a lawful and consistent manner with our other cases. So that's all.
All right, thank you,
May
Mr.
I add something, sir?
Mr. Miller, hang on, commissioners.
Yes, sir.
Good.
Mr. Jennings, with unlicensed activity, it'll always be the case that we're gonna struggle to find them because by definition, they're unlicensed. We don't know how to serve process necessarily, right?
The enforcement division performs a clear search, which is a sophisticated piece of software database that gives us addresses, and usually a number of addresses. And what the enforcement division does is if they receive a number of hits or a number of addresses for that individual, they will send the notices out to as many addresses as they need to make sure that service is proper, that these notices will make it to the individual. I don't know the inner workings of that software, but I know this has been common practice for a long time, and it yields positive results.
Can I ask about the customer, or I guess in some regard, the victim of this? You received a notice because of either faulty installation or improper work product. What was the resolution of that?
I can't speak to what the prosecutors, the prosecutor has the discretion to look at this case, determine whether or not to have a department investigator perform an inspection. And so it wasn't resolved, that particular issue. And so
I would just like to know if they were made whole, right? I mean, if there was faulty work product, did Mr. Miller pay somebody to come, ultimately do it right? Or, I mean, is somebody in Texas right now without an air conditioner suffering because of this work, or has it been resolved?
Well, from what I could see in the case, another air conditioning and refrigeration contractor was called out to fix the problems. But again, these are not issues that were vetted in a hearing, so this is all based on our investigators' records.
The commissioners.
I have one more thing to add, if you don't mind. I'm getting
Can I
word
add
from.
something?
Mr. Miller, just give me a second. I'm gonna let you speak. Just give me a second. Ms. Jennings, wrap it up on this, please.
Okay, no problem.
Yes, sir.
I'm getting word from enforcement that we received Mr. Miller's address when he provided us an image of his state-issued Texas driver's license. And so that was where we didn't just receive from Clear, although we did receive some addresses from Clear. So we had one address that was on his driver's license. And so that's what I'm getting. So that's we did use that address. So that gives me even greater confidence.
Okay, all right, Mr. Jennings. Again, it's about unlicensed activity. Let's just state of the motion for hearing. Mr. Miller, go ahead. I'll give you a minute. Go ahead.
Yes, sir. The notices that went out, I was not at that address because I was actually incarcerated at that, and it all passed.
Okay, thank you, Mr. Miller. I appreciate that. Any other questions? Okay. All right, commissioners, again, motion for hearing, just in unlicensed activity. I'll take a motion, or we don't have any questions.
I'll make a motion that we deny the rehearing.
So speak up, please. Again.
I'll make a motion that we deny the rehearing.
Is there a second?
I'll second it.
Okay, all in favor, say aye.
Aye.
Opposed? All right, motion carries. Mr. Miller, thank you. Somebody from TDLR will get follow up with you as far as what your options are. We appreciate your time. Mr. Jennings, thank you for your efforts as well.
Thank you, Chairman. Thank you, Commissioners. Have a good day.
Okay, we're gonna go to item M, which is the rules. Is it Ms. Pello Spadell? Okay, you're on screen. Okay, I don't know who's real, who's not, right? All right, you go ahead.
Good morning, Commissioners. This is Wendy Pello, Senior Assistant General Counsel for the department. I'm joined by Molly Fudel, Assistant General Counsel for the department. We will be presenting and answering the rules for under agenda item M today and answering any questions. These rules, there are 19 proposed rules under this agenda caption under agenda item M. The structure of today's rule agenda caption is slightly different from kind of our regular rule agenda items. And the reason is that there are, for today's structure is there are common background and reasons for the changes being made to these 19 programs. There are separate rule chapters and separate proposed rules for each program, and those are identified on the agenda under agenda item M, items M1 through M19. However, all of these proposed rules are the result of advisory board changes that are being made by House Bill 1560, which is the department that we could. And then we're trying to simultaneously implement the House Bill 1560 advisory board changes for the affected programs, which is why you have 19 separate proposed rules under this agenda item. As I walk through here, just kind of give you a little background on kind of what the statutory changes that House Bill 1560 made, highlights the two groups of rule changes in the affected programs, and then the comments that were received for the specific programs. In terms of House Bill 1560, as you know, this was the sunset bill for TDLR. It made a variety of changes and updates to TDLR's operations and functions and to certain programs. One of the changes we made was regarding advisory boards. And so the bill added advisory provisions to Occupations Code Chapter 51, the Department's Enabling Act. The first change that made was adding a new section 51.209A-1, which requires TLR's advisory boards to be called at the direction of the executive director or the chair of the commission. House Bill 1560 also repealed provisions in individual program statutes that conflicted with this new provision. And the second new provision that was added to Chapter 51 was Section 51.209A-2, which allows TLR's advisory boards to continue meeting by video conference and other remote means, as long as they're meeting certain requirements. And those authorized meetings are exempt for certain provisions of the Open Meetings Act. In terms of the rule changes that are before you, the proposed rules that are under agenda item M, they're aligning all of these program rules, these individual program rules, with these new advisory board provisions under Chapter 51 and under their program statutes as applicable. And there's really two groups of rule changes. The first group is making rule changes and removing the requirements for those affected programs that require the advisory board to meet either a minimum number of times or allow someone other than the executive director or the chair of the commission to call those meetings. And that's here, and this change is being made to align the program rules and make sure there's not any conflict with the new provision under 51.209A1. And there's 10 programs. We looked at all of our programs, and there's 10 of our 38 programs. 10 of our programs have a change that needed to be made. And those programs were the auctioneers, behavior analysts, boilers, breeders, driver education safety, elimination of architectural barriers, electricians, property tax consultants, tow, and the used auto parts recyclers. The second group of changes that was made were these proposed rules remove the rule requirements for the affected programs that had provisions in the rules that required that advisory board meetings be announced or conducted under the provisions of the Open Meetings Act. And that change is being made to remove those provisions so there's no conflict with the new provision under Occupations Code 51.209A-2. And again, there's 10, we're looking at our programs, there's 10 programs that were affected by this change. And those programs were the athletic trainers, behavior analysts, code enforcement officers, dietitians, dyslexia therapy, hearing instrument fitters and dispensers, midwives, motorcycle and ATV operator safety, orthotists and prosthetists, and the speech language pathologist and audiologist. And I do want to note the behavior analyst rules are in both categories of changes. We did propose rules for all these programs, all those that are listed here, submit them to the Texas Register. The 19 proposed rules were published in the Texas Register on February 4th, 2022 for public comment. Do note that each of these is a separate rule chapter, so they were published separately. Each rule change and the proposed rules included kind of the applicable background that I provided you just now, along with the specific changes for that particular program, what the specific change would be for those rules. The public comment period closed on March 7th, 2022 for all 19 programs. And the department received public comments from interested parties on some of these programs. And so I will identify those programs and kind of briefly mention the comments that were received. For the group one changes, this is the changes regarding who calls the advisory boards and the minimum number of meetings. For those programs, Four of the programs we did not receive any comments, and that was from the breeders, the driver's education safety program, the property tax consultants, and the used auto parts recyclers. Those four programs, we didn't receive any public comments. For the auctioneers, boilers, the elimination of architectural barriers, and the tow programs, we received one public comment for each of those programs, but those comments were outside the scope of the proposed rules, so no changes were made in response to those public comments. For the electricians program, we received comments from 4 interested parties, but again, all of those public comments were outside the scope of the proposed rules, and so no changes were made in response to those comments. For the behavioral analyst program, we received comments from 2 interested parties, and one of the interested parties commented on this specific change. And in this group, and the interested party opposed eliminating the rule provision requiring the 2 advisory meetings to be held per year. Regarding this change, this rule, the behavior analyst rule, is being amended to align the program rules with not only Chapter 51 changes, but the changes that were made to the behavioral analyst program statute. As I mentioned, the changes were made to Chapter 51, but certain program statutes were also amended by House Bill 1560 to make sure there wasn't any conflict. And one of those program statutes was the behavior analyst program statute, and that House Bill 1560 repealed the provision that required that advisory board to meet at least twice each year. So that was a statutory change. And so the proposed rules are being changed to align with those changes in 51 and in the program statute. In the second group of changes we received, and this again is the changes regarding those rules that have references to the Open Meetings Act or provisions about the Open Meetings Act. In the rules, we received comments from 3 interested parties. One of the interested parties submitted a comment addressing all 10 programs. One comment was addressed the hearing instrument fitters and dispensers program, and one comment addressed the behavioral analyst program. For that first interested party, they submitted one comment letter and addressed the changes being made for all 10 programs. And again, that's athletic trainers, behavioral analysts, code enforcement officers, dietitians, dyslexia therapy, hearing instrument fitters and dispensers, midwives, the motorcycle and ATV operator safety program, orthotists and prosthetists, and the speech language pathologist and audiologist program. And this interest party, the Texas Medical Association, had commented on the Open Meetings Act and the changes made by House Bill 1560. They expressed some concern about the proposed changes and suggested some alternative rule language. In reviewing those comments, the department does not believe we need to make any changes based on those suggested revisions or make those suggested revisions that were offered by the interested party. The proposed rules are eliminating the conflict between these 10 program rules and the new provision in under section 51.209A-2. The changes are also aligning these 10 program rules with other rules of the department, which do not have a provision about specifically requiring advisory board compliance with the Open Meetings Act and their rules. So this kind of aligns those programs with these rules with other program rules. And then additionally, the proposed rules are not going to change how the department conducts our advisory board meetings. We'll still follow the Open Meetings Act in terms of how we conduct those meetings. We have a kind of a long history of making sure we're open and transparent and making sure those meetings are open to the public, in fact, going beyond the requirements of the Open Meetings Act. So we weren't making any changes to those proposed rules in response to that comment. We did receive a comment from a second interested party on the hearing instrument fitters dispenser program. This interested party expressed uncertainty about why the purpose of the rules, but did not oppose the changes. And again, the purpose is to eliminate any conflict between the program rules and 51.209A-2. So no changes were made there. And then the department received a comment from a second interested party on the behavioral analyst program who expressed concern about the transparency of the behavioral analyst advisory board if the changes were made regarding the open meetings rules, then those rules were being adopted, and the interested party opposed the proposed rules. And again, in response to the concern about transparency, the department live streams all its advisory board meetings. We archive those on our website so people can view those. We make sure that those meetings, public members are allowed to, comment at the advisory board meetings by phone or video conference. So we're trying to make those very transparent. So the department did not make any changes in response to that public comment. And just in summary of all of those public comments received for those rules, we did not make any changes to the proposed rules in response to those public comments. So the department is recommending that the commission adopt the 19 proposed rules cited on the meeting agenda under agenda item M, items M1 through M19, as they were published with an effective date of July 1st, 2022. And Molly and I are available to answer any questions.
Perfect, thank you, Ms. Fellow, appreciate that. Any questions, commissioners? Okay, I'll entertain a motion.
Make a motion that we adopt the proposed rule changes on item M 1 through 19.
Effective July, Ms. Pello, July what?
July 1st, 2022.
July, okay.
Okay, that's the motion. Is there a second?
I'll second.
All in favor, say aye.
Aye.
Opposed? Motion carries. All right, thank you.
Thank you.
Good job, good job. Item N, miscellaneous strip mayor.
Yes, thank you, Commissioner. I'm here to present the rulemaking packet service contract.
We can't hear you. Can you check your mic on that, please? Go ahead and say something again.
Can you hear me?
It's just cutting out on us.
Can you hear me now?
Yeah, let's give it one more shot. Let's see if it works. Go ahead.
Okay. I'm here to present the rules package for resident contract providers, a program that came over from the Texas Commission on September 1st of 2021. The PDL rulemaking response to 18, which moved those resident service.
All right, we're gonna have to, it's just not working for us. All right, I'm sorry about that. Brad, can you either want to have somebody sub in or do you want to reset that?
Could we come back to this item?
in instead of video?
Yes, we can try some different options. Could we maybe come back to this item?
Sure.
Later?
I tell you what, we're gonna come back to you. I'm gonna table you for a second and we'll kind of confirm it down. We're gonna go to appointments. Ms. Winston, is that right? Mary, are you there? Mary? Might have taken you by surprise. I think she's here personally.
Yeah, she's here personally.
I'm sorry, I am. I'm struggling with my laptop today for some reason, but I'm here.
You want to come in here in the meeting room or you want to go where you are?
I'll head in there because I'm not getting cooperation here. Coming.
Thank you, Mary. We'll give you a few seconds. And just make sure I'll come back to that item in a minute. And I'm okay with her if she just wants to call in.
Yes, I'm sending her the number right now. Call in.
Good morning.
Why would you deny me the opportunity to see you?
I'm sorry, Commission. I was trying to be all efficient. I was at my desk. I had on headphones. I was ready and I couldn't scroll. So today, thank goodness I did have this printed so I don't have to continue to look over at the screen. We're gonna do presiding officer reappointments. It's a short list today. And we will start with the Advisory Board of Athletic Trainers. We have Ms. Brittany Webb from San Marcos, Texas. For the Dietitians Advisory Board, we have Janet Suzanne Hall of Florence. Dyslexia Therapists and Practitioners Advisory Committee, Ms. Helen Masick of Dallas. For Orthotists and Prosthetists Advisory Board, Ms. Catherine Mize of Double Oak, Texas. And finally, for Youth Automotive Parts Recycling Advisory Committee, Mr. Chad Termina of New Braunfels.
No, thank you so much. Before we do this, commissioners, this is always a great opportunity for us to get people that we can. Mary's does a great job of vetting, and so whatever help we can get as far as getting eyes on the ground would be great. I'll take a motion.
I'll make a motion.
Is there a second?
Second.
All right, all in favor, say aye.
Aye.
Opposed? Motion carried.
Thank you so much.
Well done, Ms. Mary.
Thank you.
Ms. Selena's back.
She is calling in, and I do not see her just yet. So do you wanna,
Strip matter, right?
yes,
Okay.
Mr. Chairman, we can move on to the executive office reports if you'd
Okay.
like, and still wait for Elizabeth to come on.
Is that her?
Yes, can you all hear me?
We got a heck of an echo here, so we're gonna stand by. We'll kind of
I
reset.
turned off
Yes.
the WebEx. I think that was the problem.
Okay, there you go. All right, now we can hear you. So we're gonna stay with item N. You go ahead and give us the rules if you don't mind. Service contract
Wonderful.
providers.
Thank you. I'm here to present the proposed residential service contract rules relating to the transferred program that came over pursuant to HB 1560 on September 1 of 2021. At that time, HB 1560 moved regulatory authority for residential service contracts, which I'm going to refer to as RSCs, from the Texas Real Estate Commission to TDLR and merged it into the existing Service Contract Provider Program statute as a fourth type of service contract. So what we did was we first transferred the residential service contract provider rules as they existed at TREC into the existing SCP rules that are found at 16 Texas Administrative Code, Chapter 77. We then engaged in rulemaking to bring those transferred rules into line with the existing service contract provider rules by both amending and repealing as necessary the existing rules. So those proposed rules were published in the Texas Register on February 11th of 2022. And during public comment, we received 3 comments from 3 commentors, which included 2 industry-led groups speaking on behalf of licensees and 1 current licensee. All 3 commenters expressed concerns related to the proposed rule at 77.70K, which would have mandated that licensees notify TDLR of affiliations within 30 days of establishing that relationship. After reviewing those concerns and comments, TDLR determined that there were valid issues with that proposed rule and struck it from the final draft. The next comment related to the draft language in proposed rule 77.41C, which relates to financial security and the use of a reimbursement insurance policy. After reviewing those concerns, we determined that we disagreed with the comment and we were not going to make any changes to the proposed rule. The remaining comment, the last one, relates to a specific form used in the SCP program and not to the rules themselves. So that comment has been sent to program staff and will be taken under advisement by the department as we move forward through this program. There being no further comments, we ask the Commission to adopt the proposed rules as written with an effective date of June 15th, 2022.
Thank you so much. Any questions, Commissioner? All right, I entertain a motion.
Make a motion to accept this as change for June, what was it, June 15th, 22?
Yes. Second?
I'll second.
All in favor, say aye.
Aye.
Opposed? Motion carries. Thank you, ma'am.
Thank
All right.
you.
Absolutely. We are now to executive officer reports, item P.
Chairman, Commissioners, Mike Harrisman is Executive Director for the agency. In your packet of information, we of course provided you a listing of all the staff reports, the division reports. There's a lot of information in there that they managed to be able to condense it down to almost 1 page for every single division. And so there's a lot of stats in there, dashboard type stats, I think that you'll be very interested in. I would point out a couple of them that our customer service division had received over 33,000 calls in the month of April, and that's quite a few. It's about I'm not sure, well, I had a stat on it, but I've lost it. But I would tell you that their wait time is less than 3 minutes for calls in the month of April. So which is a good statistic because we continue to have these calls. Enforcement cases have opened over 17% more than what they did in the previous year. So you can see there's a lot of volume to continue to go through the agency. And so I would encourage you to, of course, read through those stats. If you got any questions, feel free to ask. We're going to answer anything that you've got because I can tell you that they are doing their work here at the agency. So pretty proud of the work that they continue to do here. So I'll be able to answer any questions you got on the stats. If not, we can move to sunset update.
Any questions, Commissioner? Now, the enforcement increase, is that just because of the license and number of licensees we've increased, or?
Those are the cases open is what we've had for enforcement. So
Is it, I guess, does it mean what I'm saying is there is a more criminal type activity or lack of compliance, or is it just, we just have more licensees?
I think it's a matter of all of that kind of coupled together, more licensees that we have. Because if you look at the licensee stats, you notice that we have a large number also, but the cases itself would be those that have kind of a larger amount of violations that have taken place. I think now that COVID has kind of started going down, we've had more violations that start increasing because we have more productivity taking place out of the marketplace.
Okay. Go ahead.
Mr. Chairman, I could speak to that also. Christina Kaiser, Senior Deputy Executive Director. The increase in cases open in enforcement, I think, is also a reflection of the enforcement division getting past a backlog of work that was the result of turnover in our intake section. Over the last couple of years, we've had heavy turnover in that section, and that's the first group that reviews a case and decides whether to open it or not when it first comes in the door. And so when there's turnover there, new cases coming in the door are going to back up. And so this reflects to me that that's getting under control, and so I feel really good about it.
We're back to normal?
I wouldn't say we're back to normal, but we're better than.
Whatever normal is, it is. Relative
We need to
to-
And
define
normal is shifting depending on what comes in for the board.
Okay. Go ahead, Mike.
I was going to turn it over to our Senior Deputy Executive Director, Christina Kaiser, to be able to provide a kind of a sunset update for the commissioners.
Good morning again. Is it still morning? Yes. Mr. Chairman and Commissioners, I am Christina Kaiser, Senior Deputy Executive Director with TDLR. It's been my pleasure for the last 2 years to oversee the agency's work on implementation of the sunset requirements. We have some slides up and they're a little bit difficult to see, but we will do the best we can. We can certainly provide you with copies of these after the fact if you care to see them more up close and personal. So this first slide just shows some background information and key dates in our sunset process, which culminated, as Wendy mentioned earlier, in the adoption last session of House Bill 1560, our sunset bill that was authored by Representative Goldman. Our work on the sunset implementation actually started in June of 2020, before the legislative session. We started work as soon as the Sunset Commission staff issued their staff report containing recommendations for the agency. I'm not going to start back at the beginning because we have given you updates before. I want to focus today on the work that's in progress right now. There is a huge amount of work underway with several different teams. And I think of that in terms of the big 3 changes that were brought about by sunset and then kind of everything else. And in the everything else category, the smaller kind of standalone pieces, a lot of that work is completed or near completion. We'll talk about that sort of at the end of the presentation. So when I talk about the big 3, I'm talking about the merger of the Barber and Cosmetology programs, which was in issue 3 of the sunset report, the modifications to the driver education and safety licensing structure that were in issue 4 of the sunset report, and then issue 6, which was a bundle of recommendations, all designed to help TDLR develop a risk-based strategy for its regulatory functions. And I call these the big 3 because each one of them all by itself is a complex body of work with multiple major changes that are impacting the agency across multiple divisions. And this includes, in each case, a significant dedication of IT resources. Christine, you could move forward 2 slides, please. To be sure we have everything in view in each one of these big 3 issues, we have broken the work down into component parts And the idea being that each one of these component parts has to be completed for the whole to be considered complete. But breaking the work down into smaller pieces makes it easier to digest and easier to recognize, successes along the way as each piece is completed. On the slide here, again, it's a little difficult to see. We have listed the component parts, the major component parts for the Barber and Cosmetology merger. And those include several categories of merger of license types. We'll be merging license types for individual specialty licenses. So before there would have been a barber manicurist license and a cosmetology manicurist license. When this goes live, going forward, there will just be a manicurist license with no separate designation. Similarly, there will be merger of license types for establishments. So no longer a barbershop or salon, it'll just be an establishment, and merger of license types for schools. The work also includes elimination of a separate license for instructors. You have heard public comment about this change over several meetings, and conversion of all the individuals out there right now who hold instructor licenses. After the changes go live, at their next renewal, their instructor license will convert to whatever underlying practitioner license was reflected in what they were teaching. A big feature of the implementation work here has been working with IT to detail the changes that will be needed in our licensing systems and making sure that that functionality for each one of these changes is up and running and ready to go by our go live date. All of these changes must be deployed by September 1 of 2023. The work also involves a piece-by-piece review and modification of lots of licensing applications, including online applications as well as paper forms that are available for our licensees to use. Also reviewing instructions that go along with those applications, and typically an application will be 1 or 2 pages and the instructions will be 6 or 8 pages. And modifications, of course, of information posted on the website. You'll see at the bottom, well, you can sort of see at the bottom of the slide, one of the things that we have already completed regarding the Barber and Cosmetology merger is that the 2 separate advisory boards for the 2 programs have been eliminated, and we have created a new advisory board for both programs combined. That board was appointed by you in December of 2021, and the first meeting of the board was already held in January of 2022. At the first meeting of the advisory board, work groups were created for specialty topics, and the team that's working on this issue has already held multiple meetings with the work groups to make decisions about certain items that need to go into the rules that will be adopted to sort of effectuate this change. Some examples of that are the content of the new school curriculum, for the one school for everybody, and also the new continuing education requirements that will now be applicable consistently across both types of licenses. Another big feature of our work has just been communicating changes to the public and to our licensee population. We've already been making announcements as we've gone along through advisory board meetings, our website, the email listserv, and at industry meetings, when we visit out in the field. When we get closer to the go live date for all of these changes, we're planning to hold a series of summits around the state in order to invite the industry in to meet with us in person and talk and just help them get better acquainted with the changes, because there are quite a few. We can move to the next slide, Christine. Issue 4 is the modifications to the DES, or Driver Education and Safety licensing structure. The component parts for that are listed here on the slide. And they include things like elimination of the driving safety school license, which is considered a redundant license because there is also a separate driver safety provider license. Modernization of the licensing structure for driver education providers, so that now they may be in person, online, or parent-taught driver education providers, or a combination of more than one of those. Elimination of pre-license and continuing education requirements for driver education instructors. and elimination of some specialty driving safety courses. Much of the work here, the implementation work on this issue, looks much the same as what I described for Barber and Cosmetology. There's a lot of working with IT on detailed changes for the licensing system. There's a lots of modifying forms and website information, identifying rule changes that are needed, working with work groups from the advisory board, and the same is true here. The reconstituted advisory board for this program is already up and running, and the team has already been holding meetings with the work group work groups, plural, to identify changes that need to be made in the rules. Another moving piece that's unique to this program is that while all this is going on with Sunset, we have also decided to migrate this program to a different licensing system, a different database for licensing called Versa. The new system that it'll be moved into, Versa, offers improved functionality and security as compared with the system that it lives in right now. And so as that work proceeds on the migration over to Versa, the licensing requirements will be built out in Versa in this new image, in the new model as it exists post sunset changes. So that's a good example of, you know, what I said earlier, the impact of the sunset changes are kind of felt, you know, across the agency, and these two pieces have to kind of move forward together for the whole thing to come together at the end. Next slide, Christine. Issue 6 is the other of the big three. This is the requirement that we develop a data-driven, risk-based strategy for regulatory functions. The component parts are listed here on the screen, and I'll talk a little bit about some of the successes on these in a moment. So a big feature of the implementation work here has been simply identifying what data is available and how to access it in TDLR's many and varied databases. And then, once you access it, how to make decisions about that data when the data out of TULIP doesn't look the same as data out of tools, which doesn't look the same as data that came out of Versa, which doesn't look the same as came out of the existing DES database. I can tell you that this has involved a lot of manual work, pulling bodies of data out of those various systems and doing what we can to put the data in a state so that it's sort of comparable across those different programs. We decided, you know, we had to start by working with the data that we have and using the tools that we have right now, and then learn as we go along about where we can improve. And we've already learned a lot that we hope will be instructive to us when we move into a world of establishing a new database system for our licensing needs. And so as we're working out these models for things like risk-based inspections and complaint prioritization, we are also kind of at the same time exploring what technology tools are out there in the world to help us automate some of this work. So a few of the specifics under issue 6. Recommendation 6.1 requires us to establish a risk-based inspection model. We have built out a risk-based inspection model already. Eric Beverly and his team in field inspections have done that, and they have it in operation already for massage inspections. I believe they have been conducting massage inspections under that model for 2 quarters already. We're in the state right now of watching it work and evaluating what may need to be fixed before we deploy risk-based inspections for more programs. Next in line will be Barber and Cosmetology establishments. When we have Barber and Cosmetology up and running with risk-based, that will amount to 94% of all the establishments that are inspected by field inspections will then be subject to risk-based inspections. Recommendation 6.2 requires complaint prioritization. So similarly here, the Enforcement Division has built out a model for complaint prioritization, and it is in operation right now for the air conditioning and refrigeration program. Same as well, we're watching it work, figuring out what needs to be tweaked. And at the same time, the division is working with work groups from the advisory boards to develop prioritization schedules for multiple other programs, starting with the big drivers, meaning the programs that bring the majority of the work to us. 6.3C is a recommendation that requires us to develop improved inspection procedures. We have multiple initiatives underway here in field inspections and also in RPM, because inspections happen in both of those divisions. In field inspections, we are developing a new e-inspection system using a product called Microsoft Power Apps. That's in the last stages of testing, and we expect to develop that, expect to deploy that soon for the massage program. And Barber and Cosmetology and multiple other programs are expected to go on board pretty soon thereafter. In RPM, one example of an initiative is that we are in the process of converting a large amount of paper forms that are used at boxing events into electronic forms that can be completed at the event using an iPad rather than having to carry around a bunch of paper forms. So this area of improving data collection and procedures, this is, and as we're going along with sunset implementation, we have this list of things, right, that we need to get done. And we're so happy when we can check off a box and call something done. Like 2 things that you did today are checking off a box and calling it done, the 2 rule packages that you adopted. The area of data collection and procedures is something where I'm not sure we're ever really gonna be able to call it done, finish it and call it done. And I think that's because of the pace of change. The change in technology and just the change in our industries, the ongoing innovations that are employed by our regulated populations. And so I see this as an area of sort of ongoing process improvement. The next couple of pages on the slides reference some of the items that are already complete. As I mentioned, the 2 sets of rules that you adopted today. Some of these I've already updated you on in the past, and so I'm not going to spend time on that, on those 2 pages. I'm happy to answer any questions that you have. And in conclusion, I would just say, I want to really thank all of the employees who have put their shoulder to the grindstone and have been really working on this for the last 2 years. We've had, at one time or another, we've had at least 20 teams of employees working on pieces of sunset. Some of those teams have 2 or 3 people on them. Some of them have 30 or 40 or 50 people on, depending on the size of the lift for that particular assignment. 10 teams are still working right now. And so I just like to say they make me so proud. And it's an honor to have overseen and to continue to oversee this process. I'm happy to answer any questions if you have them.
Great job. Can't you wave that wand and get all that done?
We've been waving lots of wands.
I
We've
know.
been making really good progress.
So I know for the commissioners have questions, but I want commissioners to understand, right? Let me, in her 3 big 3, right? Let me give you the themes, our oversight, right? The combination is going to be continued, right? I see the consolidation as part of the art of what's happening in the next future for our licensees. Also, this licensing system, she broached that, but I cannot emphasize the effort that's going to have to be leaned into to figure out how to not only combine the licensing, but the data and the centralization of that is going to be a big deal in many facets. So we need to be mindful that in the risk-based enforcement part of it, we know criminal minds are sharp. And I know the the Financial Crime Center that we established in Tyler, the amount of time and energy, this is going to be something that we have to really be state of art, and the more data, the accurate the data, the better we are in enforcement, not only for the limited resources we have, but also to focus on what needs to be focused on, because waves come, right? Things happen. I know Dr. Callis is on fentanyl, sex trafficking. We don't know what's coming after next. So as these things adjust, we need to be very mindful of that. So outstanding job. Whatever you need from the commission, let me know. We'll lean into as much as you can. We can pick the pockets of legislators all day long, so we'll figure this out. All right, Commissioner, any questions you guys got?
Great job. Thank you for keeping that all together.
So, Mr. Butler?
Yeah, a couple of questions on the licensing system. So when a member of the public calls in and asks a question about electricians, will there be one central system which your frontline customer service will be able to pull up any license program of our 28 licenses or whatever it is now? Will they be able to ask any questions, whether it's dog breeders, athletic trainers, massage therapists, electricians, air conditioning? What is the front line going to look like?
So that is the goal, to, at the end of the day, have one overall system for all of our licensing needs. Now, obviously, getting from here to there, that's not gonna be an overnight thing. It will happen, I suspect, in stages, with clumps of programs going in at one time. Kind of like I talked about earlier, breaking it down into smaller pieces
Sure.
to make it digestible. So, yes, ultimately, as far as the customer service division, they have access to the various systems now. And I don't see why they wouldn't have access to this new combined system in the future. I will say that I believe, and don't have me speaking out of turn, but I believe the customer service folks are specialized, however. And so if the person who picks up the phone, if they are not specialized in whatever program is asked about, then someone else might need to help that person. But your ultimate question, yes.
So, you know, our personal experience, if somebody calls the credit union and says, my credit card, you know, has been compromised, we have to log into one system. If they say, you know, can you check the status of a check, has it cleared, we have to log into another system. I just want to avoid as much of that as possible in the licensing system because it takes time, right? And it may take, you know, 2 minutes to log into one system, get out, 2 minutes to log into another system. And that's just two products, right? And so all of that, you know, as much as we can cut out.
And are they talking to somebody? Is it recorded voices?
They're actually talking with someone at customer service and Vice Chairman Butler, even if someone's called in for a particular program, then our customer service or anyone in licensing, they go into a particular program based on the question and the program that they're asking for. Whether it's in our Versa system, the Tulip, or any other system, they go to that particular one, so they would access from there. And as Christina Kaiser was mentioning and stated, ultimately, we hope to be able to have just that one system that they go into. And understand that that's kind of what we're working at, and I think we brought you up to date on the licensing system that we're currently, you know, endeavoring on. And that's gonna be a multi-year project. When I mean multi-year, I mean, it's gonna be probably at least minimum 4 years, up to about, you know, maybe 7 years before we actually get to that point. So it's gonna be a multi-year project that we're able to get to that point where we know that we've got just one system that staff enters into and they have everything at their fingertips.
And in terms of funding, is this something that, I mean, so when you sit down with a system analyst and they daydream and doodle, you know, what it's gonna look like at the end stage, is this something that you would endeavor on the front end? Or are you gonna say, you know, as we build this airplane, you know, are you flying it as you build it? Or, you know, have we set up a plan to see what we want at the end stage and then develop a budget for that? I know you're working with is it the Texas?
DIR.
DIR.
Right, there's still conversations going on with DIR to figure out which pathway we go on that, but we have, essentially right now, we have those two conversations going on, one with DIR, one internally for us on the RFO that we're looking at. So depending how that conversation progresses, we'll be able to get to a resolution, hopefully in the next few months, that we can begin to know that we're actually moving into a particular direction that helps us get to our ultimate goal. So it is a long-term project, and in meetings that we've had with legislators, they've asked, what is your number one challenge? And the challenge that I tell them is having multiple systems, and we need to get to one licensing system. That is the ultimate challenge that we're currently facing at the agency.
Any other questions? It's Mr. Butler, it's gonna be interesting. Just to give you a little gravity, right? From the beginning of mankind to the 2000, we have X type of information. In the year 2000, 2022, we have 10X. So the dynamic change in our world as far as information and technology has been 10 times the level from the beginning of mankind to 2000. So we understand that the fluidity of what you're doing, not to mention COVID, snowstorms, King Kong, Godzilla, whatever's coming next. I'm not sure what's coming next, but it's coming. So whatever that happens. So whatever we need, and I know the legislature, and I'll tell the commission very clearly, the legislature is very much willing to listen to what our needs are. So whatever we can do, let us know, staff, and lean into it, because the funding should be available hopefully to us to be able to do this. I'm excited about it.
And depending on which direction we go, will determine what our legislative appropriation request will look like once we have to submit it. So that's kind of the next project that will be coming down the pipe for our staff to get start working. So
I would just ask that we be part of that conversation
Sure.
right as we go forward. You've done a great job, excellent job communicating to us what's going on. And I just kind of want to make sure that we're part of that conversation, big picture. What's it going to look like, and then the steps along the way.
Definitely, yes, sir. I do want to kind of give credit to Christina Kaiser. She's kind of been steering this ship, and as you can tell, other communication we've had with legislators, we told them that the sunset bill, it was a heavy lift for us. When we began to start taking a look at each issue that was presented to us and the work that had to be done, you know, it's not just a matter of sprinkling the pixie dust on there and saying, okay, it's now done. The largest component of that, we got extended for 12 years, which is good, but then all the other things below that of saying, okay, now these things you need to change. And so Christina Kaiser was tasked with this project, you know, with previously by Brian Francis, and when I stepped in, I said, you know, I'm not touching this, it's still your project. So she's managed to be able to carry it and move forward. As you can tell, she's very, she's got all the intimate details on this particular project. And so anything that you ask concerning Sunset, she can answer me because she's that much familiar with it. So if you ask me a question, I've got to go to Christina Kaiser to get the answer. So just kind of be aware of that. I'll move on to the State Auditor's Office update. I believe, Commissioners, I sent you the engagement letter that we received from SAO. So we're now in the process of working through that. This is a task that I've tasked with, I put on to our Chief of Staff, Elimination. So his crew will be working on this SAO audit. They have a very aggressive schedule. The letter was sent out to our General Counsel, Brad Bowman, through the correspondence that he has with them, and then it was kind of filtered out down into staff. But him and his crew will kind of run with this. As I mentioned, it's a very aggressive schedule. We're looking at from May to about August doing the audit, and it's primarily auditing performance measures and how it's input into what they call the AVES system. But that particular project is looking at completion somewhere around August, and they can have a report done by September to be able to submit. You'll be able to see that as we progress through it. But him and his divisions, we will be working on this with Tony Kubion, his budget analyst. They'll still be working on that also. And just kind of get you some idea, they're coming out of the strat plan into the SAO audit, and they come out of the SAO audit, they'll be moving into the LAR. And so they've got their year already mapped out for them, and then we'll move into session. So they're pretty much set and ready to go in that respect. But you know, this is all a part of the numbers and what we have to do with the performance measures. So it fits right up their alley in that division to be able to work on this. So we'll continue to provide you information on the SAO as we progress forward.
Anything else?
That's all I've got.
You sure? We probably had another couple SAR, Sunset, LAR. We gotta run a commission too while we're at it.
I'm ran out of acronyms.
You can sleep later. Well, and I know, great job, team, on what you're doing. Also, I love the updates.
I do too.
So they're great, summary, concise. I appreciate it. I know I talked to commissioners, they all appreciate that insight. Keeps us sort of just blind during in between meetings. All right, is that it for you?
That's it for me, yes, sir.
Did I miss anything?
Yes, sir.
Good, Mr. Bowman?
Good, sir.
Excellent. Get all your B plus, minus, all right. You're good out there.
Good
All
work.
right, commissioners, the next meeting is gonna be August. We're still working on dates. I'm texting as we speak with Dr. Callis and trying to, Ms. Callis, you're trying to figure out what it is, but cannot emphasize it's good to have you guys here in person. Well, some of you, good to see you, Laura. So August is we're looking at, probably the first week of August is what we're looking at. So I will get that out to you next, probably this week, latest, to get you, that way you can clear your calendar. And we'll kind of go from there. October, December will also be the follow-ups, and I think that is it. I'll take a motion to adjourn. Second? All in favor, say aye. Aye. Meeting adjourned.